jurisdiction is so hyper-technical is the fact that federal judges usually aren't thrilled about removed cases. Many, not all, maybe not most, but many federal judges don't like diversity lawsuits in their court. And many cases that are removed from state court involve diversity, and that's the basis for having them in federal court. And so again, federal judges may look for a way to get rid of removed cases because they can focus on cases they're more interested in or think more properly belong in federal court. The statutory basis for removal is Section 1441 of Title 8 of the United States Code, and there are two bases for removal. The first is diversity of citizenship, and the second is federal collection jurisdiction. What that means is if there is diversity in a case such that the plaintiff could have filed in federal court to begin with, then the defendant can remove on the basis of diversity. You need to be careful because including Doe defendants in the case in the Ninth Circuit will defeat diversity jurisdiction and therefore prevent removal, although that case is now on appeal to the Supreme Court, which has granted cert. It's a case involving Ford Motor Company. With respect to federal collection removal, if there are federal claims in the complaint in state court that could have been brought in federal court to begin with, then the defendant can remove all or some of the claims in the case to federal court. The procedures for removal are set forth primarily in 28 U.S.C. Section 1446. Essentially, the defendant files a petition for removal in the district court for the area in which the state case was filed. The petition contains a statement of fact showing that the defendant is entitled to remove. And unlike most things filed in federal court, this has to be a verified pleading, and it is subject to Rule 11. So a lawyer better make sure that there's a basis for removal before submitting a verified removal petition. The party removing, generally one of the defendants, must notify all the parties of the removal and file a copy of the petition with the state court in which the action is filed. And once the party does that, the state court can't do anything else in the case unless the federal court remands the action to state court. It effectively divests the state court of all jurisdiction. The removing party has to file a bond in federal court in the event that the removal is wrongful and the plaintiff is injured thereby, but unfortunately under Local Rule 290-4, the amount of the bond is specified at $250. Probably won't cover Xeroxing costs for the remand petition. The timing of removal is very tricky, and again, it's one of the places where you have to get everything technically right. The statute provides that a case may be removed within 30 days after receipt of the complaint by service or otherwise, and that or otherwise language is very tricky. It may be that if your client isn't properly served, but as a courtesy, the other side drops the complaint on you, that constitutes receipt otherwise. So you may think they're doing you a favor. In fact, they're precluding removal. In addition, if your client reads in the newspaper about the lawsuit and sends a messenger down to the courthouse to photocopy the complaint, that may constitute receipt otherwise. The cases go both ways on that. In addition, a case that isn't removable initially may subsequently become removable. For example, let's say a plaintiff decides he wants to stay in state court, and so he includes Doe's even though he knows there won't be any. And when the plaintiff files the ad issue, he drops the Doe's in state court. At that point, the time to remove begins to run. Similarly, the time to remand from federal court to state court can change. It may be that when a case is initially removed, it's properly in federal court, but that down the road the plaintiff dismisses the federal claims, and the only claims left are non-diverse state law claims. At that point, the plaintiff can move to remand to state court. If you're a defendant, the tendency is to be somewhat knee-jerk about removing to federal court, and you want to think twice about it. For example, some claims may only be brought in federal court to begin with, such as claims under the Securities Exchange Act of 1934. You can't bring those in state court. If a plaintiff sues your client on a 34-Act claim in state court, you can move to dismiss and you will win. And they will then have to decide whether they want to bring an action in federal court. It may be a little embarrassing to their client. On the other hand, if you remove that case to federal court, you've cured that defect. And even though it wasn't properly filed to begin with, it's now okay in federal court. So you should think through all the strategic ramifications and not just have what many defendants' counsel have, which is a knee-jerk preference to be in federal court.
Okay, I said we're going to get practical. Now we're going to get very practical. Because the topic is, how do you actually get a federal case filed and get it served without embarrassing yourself or worse in federal court? And if you take a look at the Federal Civil Procedure, And if you take a look at the local rules of the Northern District of California, I suggest to you, if you put them all together and look at them carefully, you are going to see that the way to do it most practically is follow the following. I think it's a 7-step process. And let me review it for you. First of all, you've got to remember to get admitted to the Northern District of California. If you are not, you must be admitted to practice in the Northern District of California. And you can get admitted by simply asking the clerk's office at the address that Doug gave you earlier in the program to send you an admission package. And they'll send you one, and they'll fill out the form, and then you'll contribute $20 to the Northern District of California Library Fund, and you will most likely be admitted to the court. That's step number 1. Step number 2 is you've got to figure out, if you've completed all your fact investigation and your research and you're ready to sit down and actually start drafting a complaint, what this thing's got to look like. What are the rules for formatting it and for the form of the allegations and whatnot? If you look at the local rules, and in particular local rules 120 and 200, they will tell you just about everything, from paper size to paper color to where the numbers ought to be, to what should be in the left-hand corner, what the caption should look like, almost everything that you'll need to know. They give you some specific instructions about what to do about a jury demand and how to make sure that it is clear from the face of the complaint that the jury is demanded, if indeed it is. They will give you the specific rule I mentioned before about having a separate titled paragraph in the complaint where you address jurisdiction. And if it's a class action, similarly, the local rules will instruct you to specify that on the face of the complaint and in the body of the complaint to set forth in a separately titled paragraph your class action allegations. Every document in federal court, including the complaint's got to have one of these little trailers, the thing at the very bottom that identifies just in abbreviated form what the document is, so that if it should ever fall apart, someone can put it back together and figure out which pages go with which particular document. And the local rules tell you about that trailer or that simple abbreviation at the bottom of the page. If you're interested in looking at the form of the allegations and what the rules are for the way you plead allegations, turn to the Federal Rules of Civil Procedure and look at Rules 8, 9, and 10, where it will tell you that you must have a short, plain statement of your claim. It will address such matters as how you plead fraud, how you plead mistake, how you plead capacity, other special matters. Those rules will also tell you that the federal courts want separate numbered paragraphs, and to the extent possible, each numbered paragraph should be limited to a single set of circumstances, and so on and so forth. That's how you decide what the format of the complaint is. Next, you've got to fill out, as a third step, something called a civil cover sheet, which is a document you get from the clerk's office. And it comes with a set of instructions as to how to fill it out. It's a front and back form, and it takes sometimes some consideration and thought to figure out exactly how to fill it out. But it is essentially an administrative document for the court. It tells them what kind of a case it is, and it permits them to keep track of the kinds of cases that they're getting and other information as well. But the key for us is if you don't have it, they will not accept the complaint. You've got to have a civil cover sheet. Next, summons. Prepare the original summons and as many copies as you need in order to serve the complaint. Fifth, and this one's optional, if your case is related to some other case in the federal court, as Boris referred to earlier on this related case document, you must prepare a notice of related case. And that can be a case that was in the court years ago and has since been dismissed. If your case is related to that, you file a notice of related case. It is a mandatory obligation. Sixth, you need money. $120 is what it costs a day to file a complaint in federal court. And seventh, you've got to take some extra copies with you. Ordinarily, the clerk's office will take the original and one copy. It is customary in federal court to have a courtesy copy delivered to chambers, particularly of important documents that you're filing, such as complaints and key motions. In addition, you want to, whatever copies you want to have conformed and bring back to the office. I'm going to give you maybe one of the most important practical tips I can give you in this course for the Northern District, because I'm going to give you the name of the person to call if you have questions during any portion of this process. He gave me permission to do this. I talked to him today and warned him that I would be doing this. His name is Bob Monet, M-O-N-E-T. His number is 556-3031. He can save your life in federal court. And I think what Bob said to me on the phone today is instructive of why the federal court can be different. Bob said, please give them my name and tell them that if we can work together, we can make this whole process much easier for both of us. And he will do that, and he will